Friends, video number 1418. During the initial classes of the jurisprudence, we have discussed the legislation, why legislation is important for the framing of the statutes and what are the different types of legislation, what is supreme legislation, what is subordinate legislation. So please remember, I told you the supreme legislation of course may be by the assembly or may by the parliament. Subordinate legislation, the rules framed by the concerned departments or concerned courts. So subordinate legislation is also equal to legislation, that is statute, that is it is also law as per Article 13 Clause 2 of the Constitution of India. So please remember, subordinate legislation is also law. This was enunciated or held to be fit by the Honorable Supreme Court of India in a very recently delivered notable judgment. Now let us see the judgment. The Supreme Court stated that subordinate legislation or statutory rules, normally subordinate legislation is the shape of rules only, is also law, even as per Section 23 of the Contract Act. Right. While allowing the appeal filed by Mr. G.T.Girish, in the case of G.T.Girish versus Y. Subbaraju, of course Subbaraju is not there, represented sometimes by wife and some other persons. Now they have become D1A and D1B, two persons. So C.T. Girish versus Y. Subbaraju in Civil Appeal number 380 by 2022 on 18/1/2022, two judges bench, Honorable Justice K.M. Joseph and Justice P.S. Narasimha, you may know he is an Andhra man who has risen from the lawyer's quota, P.S. Narasimha. They held that subordinate legislation is also law, even as per Section 23 of the Indian Contract Act 1872. Right. So now you can see the citation in a live law SC number 62, live law 2022 SC 62. Right. If you go to the facts of the case, it will be easy for you to understand the problem because it's a civil case. Normally, it's not that easy to understand the civil cases. So, this happened in Bangalore city. So, Mr. Subbaraju, this is a dependent, Subbaraju is no more. Mr. Subbaraju was allotted a flat by the Bangalore Development Authority in the year 1979. On 4/4/1979, the BDA has executed a lease cum sale agreement to Subbaraju. So there was a lease cum sale agreement. That means there is a clause that this Subbaraju should not sell away or should not alienate this plot to anybody for 10 years, for a continuous period of 10 years. That means after 1989, he can dispose it to some other person. Till such time, he should not dispose it to anybody. This is the clause. But keeping aside the clause, on 14/5/79 itself, he wanted to dispose the same to Mr. C.T. Girish. Actually, of course, the talks went on 17/11/1982. 17/11/1982, Subbaraju entered into an agreement with Girish for sale. He has taken the total sale consideration of 50,000. Please remember, this is in 1982. And the condition was within a 3 months period, he should get it registered after the whole consideration was, almost he has taken the whole consideration. Right, 3 months period was put for the agreement. But Subbaraju did not come forward for registration or fulfillment of his performance of his specific duty. Therefore, now for a lot of correspondence has taken place between Girish and Subbaraju, and ultimately, since Subbaraju did not get the register the land, this matter went to the Honorable Court, civil case. So Subbaraju filed his written statement also, but in the meantime, he died and his dependent, maybe wife, she has stepped into his shoes. Right. The civil suit was instituted on 14/2/1986 after 4 years of protracted litigation. 3 months period, but it has extended to 3 years. Of course, you may be knowing the limitation period is 3 years. Right. And the trial court did not issue the decree in favor of Girish because already they know that the litigation, that is till 1989, there is an embargo basing on the BDA rules. And therefore, actually what they have done is the trial court directed Mr. Subbaraju to return 50,000 relatives of the defendants. So to return 50,000 to the plaintiff, that is G.T.Girish, with 9% interest. So agreed by the decision, he has approached the Honorable High Court of G.T.Girish, I think Rajasthan also same thing. So he has approached the High Court. On High Court of Karnataka. This happened in Karnataka. So High Court, he has taken into consideration of Section 52 of the Transfer of Property Act. So here there is a consideration. There is an agreement. The consideration was given in full. So therefore, the rules, after all the rules, rule number 18 clause 2 they have stated. Rule number 18 clause 2 of the Bangalore rules of allotment for housing 1972. They said these rules, after all, they are subordinate rules, subordinate legislation. When the main, what is Section 52 says, when there is enforcement, when should there be enforcement? When this man has executed an agreement, definitely it is equal to. Therefore, they ordered for the decree. That means this man can get the land registered in his name. So agreed by this, High Court allowed for the decree. So, as the plaintiff, Mr. Girish, paid the entire transaction. But now, the matter came to the Supreme Court. In the Supreme Court, both the defendants, they argued that the agreement itself is unlawful. The sale agreement itself is unlawful because of the clause of Rule 18 clause 2. Because till 10 years, they should not entrust or they should not sell away the property to any other person. High Court said it is a subordinate legislation, don't care. Section 23 says illegal object, if the contract is for illegal object or a consideration, it will not be valid, it is void. But here Supreme Court once again stated that definitely this contract or sale agreement is not enforceable because of the subordinate legislation. Subordinate legislation is also a legislation. Therefore, the defendants, they have to give back the money. Now the money has gone to, I think, 20 lakhs. So these people, they have to pay 20 lakhs to the plaintiff because the property is now worth about 2.5 crores. No doubt, enhancement is there. But anyway, very good judgment. Here the important point to note in this case is subordinate legislation is also legislation. Please don't be under the wrong impression that there are only rules, we need not follow the rules. Rules also have to be followed. That is what is asserted by the Honorable Supreme Court of India. Right? Please study the judgment in detail. Otherwise, it has discussed about subordinate rules, conjectures, all these things. Jurisprudence students must read the judgment to enrich their knowledge. That's all. Thank you very much.